Sounds good.
Thank you to everyone for making it out to our live webinar today, hosted by the McGill Journal of Sustainable Development Law, also known as the MJSDL. We are thrilled to be hosting Professor Abate from Monmouth University in New Jersey, from the Department of Political Science and Sociology. Initially, we had planned to host an in-person lecture in Montreal at the McGill Faculty of Law, but of course, due to circumstances beyond our control, we unfortunately had to cancel the event. Nonetheless, Professor Abate was kindly open to the idea of hosting a webinar of his book talk, and we are so grateful for his enthusiasm and receptivity. As a silver lining, this circumstance has enabled us to broaden our reach, and we are thrilled to welcome guests from all around the world to tune into today's event. We have never yet hosted a live webinar before, but these unique times are proving to foster innovation, flexibility, and creativity at an unprecedented rate. As a student-run peer-reviewed journal from McGill's Faculty of Law for over 15 years, we are proud to provide a forum in which the world's leading scholars exchange ideas on the intersection between law, development, the environment, economics, and society. We are currently accepting articles on a rolling basis and are publishing our 16th volume this upcoming year. For more information, please see mcgill.ca/MJSDL, and we also invite you to visit and like our Facebook page as well. I'd also like to take a moment to thank our incredible team of 25 editors, many of whom I see are in the audience today. The successful operation of our journal would not be possible without the dedication, support, and enthusiasm of our incredible team. So before I turn things over to Professor Abate, I'd like to briefly introduce our welcome guest. Professor Randall Abate is the inaugural Rechnitz Family and Urban Coast Institute Endowed Chair in Marine and Environmental Law and Policy, and a professor in the Department of Political Science and Sociology at Monmouth University in West Long Branch, New Jersey. He also serves as the director of the Institute for Global Understanding at Monmouth. He teaches courses in domestic and international environmental law, constitutional law, and animal law. Today's presentation is drawn from Professor Abate's book, Climate Change and the Voiceless, recently published by Cambridge University Press in October 2019. There will be a few minutes dedicated to a question and answer session at the end of the presentation. Please feel free to send your questions through the chat or to ask questions directly by unmuting your microphone during the Q&A period. And as a general housekeeping rule, we encourage you to turn on your cameras for a more interactive presentation, but kindly ask you to mute your microphones during the lecture to avoid distractions during the presentation. So without further ado, I'd like to hand things over to Professor Abate. Thank you so much for being with us today, and we're really looking forward to hearing more about your research.
Thank you so much for that kind introduction, Camilla, and grateful for the journal's hosting of this talk. Of course, it was unfortunate not to be able to travel to Montreal and do this in person, but we are in a new world, which is a part of what my comments will address. And I think that this webinar format is really an exciting opportunity to reach a broader audience and engage in this new normal that we're facing. Just prior to a month ago, I used to call climate change that new normal that we're facing, and now we've got an added layer of complexity to navigate as we move forward, and as we hope to engage in better environmental stewardship. The recent COVID crisis dovetails a bit with the climate crisis we were already facing, and so that's a relevant side note for my remarks today. So this has been a project that started in well, several years back, really. It's a marriage of different strands of my scholarship. So I've been involved in climate justice research and teaching, and animal law research and teaching, and also much earlier in my career, general environmental law and natural resources law. So it was really exciting to bring this book project together in how it unites three related but distinct strands of my work as a scholar and teacher, and in particular to put it into the climate change context, which has been the focus of my recent work in the past decade. So my slides are not advancing. There we go. Okay, so what I want to share with you are 4 different components of the material that I want to convey, and I'm very invested in getting input, and we will have as much time as I can allow in covering this material in a way that will hopefully inspire some questions and then get a dialogue going for the last half hour. So I want to introduce you to the concept of the book, just some basic principles at first, and then talk more historically about the need for a paradigm shift in how we regulate environmental issues and climate change in particular. And from there, take a look at case studies that are happening independently, and part of the book's premise is that there needs to be a mutual supporting of these initiatives going on in the context of climate change regulation. So we'll be looking at each strand individually: climate justice litigation, that's been very active in the past 5 years or more, protection of wildlife initiatives, and animal personhood, and then rights of nature as a separate but related initiative. So I'll talk about what I mean by the voiceless, and these are the 3 categories of the voiceless that we'll look at independently in those case studies, and then the proposal will look to merge how those 3 distinct strands of the voiceless communities can be protected collectively as a strategy in how we address climate change to be more of an ecocentric model rather than the anthropocentric model that we're currently working with. So in terms of what the term voiceless refers to, it's got a lot of different reference points in the law and policy domain. So my use of the voiceless refers exclusively to these 3 domains. So this would be future generations of humans, and that would include current youth and the unborn. And a second category would be wildlife, not all animals, but wildlife as distinguished from animals that are owned companion animals and used for other purposes such as entertainment and so forth. And the third category being natural resources. And this is essentially the domain of natural resource law and policy, the protection of wilderness areas, the protection of fresh water and marine water, protection of how we manage natural resources. So these 3 domains essentially share one thing in common, that is, they don't have a legal voice to represent their own interests in our legal system. And when I say our, in many cases, I'm referring to US examples, but these are widely applicable outside the US. So the notion of being voiceless is a legal reference in the sense that they lack the ability to represent their own interests. So in all 3 instances, these voiceless communities require someone to represent their voices in court or in a legislative process. So that's the first point, understanding what voiceless means. The second point is how these communities are interconnected. And this is a question that I get quite regularly in delivering this book talk, and that is, you're unique in considering human and non-human interests in the same topic of legal protection. It's typically parallel worlds that aren't overlapping as far as how the law treats protections of humans versus non-humans. They are very distinct boxes of regulation. And so I use this slide to reinforce how these 3 communities, regardless of the fact that one is human and the other 2 are non-human, they are fundamentally interconnected in terms of their vulnerability and in terms of their lack of a legal voice. And so that sense of collective vulnerability and the need for collective representation is really the starting point for the book's premise in identifying the vulnerability and the interconnectedness of the voiceless. The next point that really defines the book project's conceptual framework is the notion of how climate change relates to the common vulnerability, the common need for a legal voice of these in these voiceless communities, and how climate change is a common enemy to these three communities. So when we look at strands of litigation that are going on in the voiceless communities, we certainly see a very robust strand of future generations litigation in the climate change context. And that is something that is proceeding very effectively. I'll discuss some of those case studies. But what the book does from there is that there are also ways in which voiceless interests outside the human community are also advancing. So I'm going to look at share some case studies with you on wildlife protection in that regard, and some case studies on natural resources, rights of nature protection. But it's important to note that the non-human voiceless communities are not advancing their cause through the lens of climate change. This is happening almost exclusively outside the domain of climate change. And so a premise of the book is, because climate change is a common enemy to the three categories of the voiceless, it's exacerbating their vulnerability and also drawing more attention to their need to have effective legal representation. In a perverse sort of way, climate change and the threats it's posing create an opportunity for forcing this need for the paradigm shift to take a more ecocentric approach to how we address protection of the voiceless in the climate change era. And actually, it's not just because it's important to protect the voiceless. If we do an effective job, a more effective job protecting voiceless communities, we are also enhancing resilience for adult humans as well. So we have to stop thinking in this dichotomy of human interests and the interests of non-humans and the interest of future generations of humans as something fundamentally different. They're fundamentally interconnected, both within the voiceless community and across voiceless and adult human communities. We are in this shared threat together that climate change is posing. So there is an opportunity for both sets of interests to be better protected through an ecocentric approach in climate change regulation. So these next two slides I share with you as kind of a conceptual reference point. And I start from the idea that humans are, in the grand scheme of things, very self-important in what they perceive their relationship to the rest of the world to be, and how they perceive their relationship to the planet. And essentially that's been an extractive, exploitative relationship. And these two slides show how not only are humans taking and not giving to the notion of environmental integrity and sustainability, but they have actually barely been on the planet in the long view of the planet's history. So if we condense the planet's history into a calendar year, we see on this first slide, humans aren't even on the scene yet and the year's almost over. And then when we get to the second slide, what we see as the primary threat to the future of our planet and its inhabitants, essentially the rise of the petroleum era that has caused climate change to advance the way it has. This is literally a blink of an eye before midnight in that calendar year. And this is the fundamental existential threat to human and non-human existence as we move forward in the 21st century and beyond. So I share this with you because this underscores this notion that humans have had dominion over the planet as long as they've been here. And that's something that Pope Francis alluded to, and a wonderful environmentalist Pope Francis is. He's really raised a lot of awareness about the need for better environmental stewardship. So in the Bible, there's reference to humans' dominion over nature. And one way of thinking about dominion is it's there for your disposal. You can exploit it and do it in an unsustainable way. It's all there for you. You just go and take what you need. Another way of thinking about dominion, though, that I share with Pope Francis's view is that dominion really is about stewardship. You're in charge. You are the one who has the capacity to ensure that this planet has something to live for and essentially protect in the future. And so that's where the ecocentric model comes into play. The idea that if humans play a stewardship role rather than an exploitation role, this is the long overdue transition that our legal system needs for environmental governance, climate change governance in particular. And it really is a moral issue, not just a legal issue. And so there are some quotes here that underscore that notion that humans themselves are essentially a force of nature that's every bit as threatening as the forces of climate change themselves. And this idea of learn and unlearn and relearn as the mode of moving forward, ultimately, we are at a critical juncture now where we need to unlearn this anthropocentric approach to climate change and our relationship to the planet, and relearn the fact that we are part of nature and not the master of it in a way that is just there for our taking. And so we're at a very critical time now with climate change and most recently the COVID crisis posing urgent threats to how humans navigate their relationship to the non-human community on Earth. And the question is, how did we get here? Have we ever had a point in our history of regulation where we were thinking this way about the value of ecocentric rather than anthropocentric regulation? And how do we get there? How do we get this transition to happen? And so this is the historical component that I want to briefly share with you to get us on a common footing. And again, this is a US reference point, but certainly applicable in many Western, certainly regulatory systems that have robust environmental laws at the federal level. So what we essentially saw in the environmental protection revolution, if you will, there was a lot of discussion about this idea of humans' relationship to nature at that time among scholars, among jurists. But ultimately, the approach we adopted in the US was fundamentally anthropocentric. This was lauded as a massive victory. In many ways it was. We were essentially industrializing at such a rate that the environment was utterly trashed. We were choking on air pollution, water pollution, land-based pollution, and it was a crisis. And it was a crisis that the federal government in the US responded to effectively with the aid of science. Science was telling us that these pollution challenges are killing us, and we need an effective response through our regulation. And so at that point, there was an opportunity to not just protect humans' interests. We certainly had effective pollution control laws that were driven by the need to protect human health and safety. And they worked quite well in that regard. The Clean Air Act, the Clean Water Act, our hazardous waste laws. And ultimately, most of the regulation stopped there. It did not go beyond this way of protecting humans from the threats we have caused by being ineffective stewards of environmental protection, of environmental resources. There were two examples that departed from that model, and those I want to note. One is the Endangered Species Act, and this is very much of an approach that is more grounded in the notion of intrinsic value of wildlife, in the sense that, and not just wildlife, but of plants as well. The idea is that there is something so essentially valuable in maintaining any species, the loss of which could be catastrophic in an ecosystem where that species is located, and can have ripple effects throughout that ecosystem. The Act is very unconditionally aggressive in protecting against the loss of species, and it adopts more of an intrinsic value approach. It's not premised on a cost-benefit analysis the way the pollution control laws were. And then a second approach, the National Environmental Policy Act, along with the Endangered Species Act, these two are considered perhaps the two most effective laws, strangely enough, that they're not based on that cost-benefit analysis. They're not exclusively focused on protecting human concerns. The protection of future generations is language built into our National Environmental Policy Act back in 1970. And the notion of sustainable development was really ushered in with the National Environmental Policy Act. The notion that we have to be mindful of how we engage with consumption of resources, that ultimately it is not an inexhaustible buffet for our needs. And so these two acts really could have been more the norm rather than the exception, but that's not the road we took in the 70s. So the vast majority of the laws in the 70s were this anthropocentric model of protect humans from the harms that we've caused to environmental resources that are in turn affecting us. And only these two examples, prominent examples, were taking that other approach that I'm advocating for, that we need to take now with respect to climate change, this more ecocentric, intrinsic value approach of voiceless communities. So I share this next slide with you to give you a sense of there is some hope in that our regulatory paradigms do shift. They move at a glacial pace, but they do shift when there is information brought to regulators' attention about how existing laws aren't quite addressing the full picture. So what happened about 2 decades after the pollution control laws worked very well at cleaning up our pollution messes, it came to our attention that these laws were not protecting humans equally. We were essentially seeing disproportionate impacts of pollution in minority communities, initially detected in African American communities, but also the lens broadens to other minority communities and indigenous communities as well, and low-income communities. So this was known as the environmental justice movement and came on in the late 80s into the 90s, the real push. And this movement is significant because it marked a shift in how environmental law worked in the country. Now, environmental law wasn't just about protecting against pollution and how it was harming our health. Now we had a human rights lens on top of what we were already doing to protect the environment from pollution problems that threatened health and safety of humans. So this model ultimately led to our climate justice model that is worldwide being adopted now. The idea that climate change is posing disproportionate impact to vulnerable populations, very much the same populations in many ways, but at a global level, we're not just talking about communities within nations, we're talking about entire nations now when we take a climate justice view with respect to sea level rise. If we look at island nations as being vulnerable as an entity to climate change impacts. And so this idea of the law shifting to become more sensitive to the needs of the vulnerable, I share with you because that's one step toward where my book is proposing we need to get. And that is one step beyond this sense of being sensitive to vulnerable communities. We're being sensitive to vulnerable human populations, adult human populations. And now we are poised to move one step beyond this environmental human rights view after we were exclusively anthropocentric pollution control view. The next logical step in this progression is an ecocentric model. And that is premised on 2 points that I want to trace through the proposal that I shared with you. And that is, we need to have enhanced government stewardship commitments. And that's what we'll see is very much the focus of the youth climate justice cases. They are seeking to have the government raise the bar in how protective they are of vulnerable populations like current youth and future generations and how climate change threatens their future. So that's one aspect. We want to enhance government stewardship in this time of crisis. And the second piece is we can't necessarily rely exclusively on raising the bar for government and expecting it to happen if we are not the least bit cynical about where we've been on that in the past. So where we also need to go is building a rights-based system to the extent the government fails in raising the bar and being better stewards of the voiceless communities. A rights-based system where those voiceless communities can be represented to hold the government accountable for failure to meet that higher standard. So it's two components that work fundamentally in harmony in an ideal world. So the case studies I want to share with you, and these case studies could easily consume the rest of the afternoon on their own. So this is of necessity very much of a thumbnail sketch, but I want to share with you at least some prime examples of how each community of the voiceless has seen a lot of activity and a lot of success in advocating for their causes individually without recognition of the other two voiceless communities. So in the climate justice domain, first I want to separate this world into two big pieces, and it's that first piece that matters for the book proposal. The second piece matters indirectly, and it's an area where I'm exploring scholarship right now, but this is not as focused as the first line of cases. The suits against the government are the ones that are primarily driven by future generations as plaintiffs, the youth plaintiffs. The suits against the private sector are typically not. These are brought. The Philippines Carbon Majors petition was brought by individuals on a human rights basis, but the lawsuits we're seeing in the U.S. against the private sector are typically brought by states and municipalities who are left holding the bill of climate adaptation in their communities, and ultimately they are suing the fossil fuel industry for being a big part of that outcome that they as the state or the city have to clean up in terms of climate adaptation. So on the youth domain, the suits against the government really are motivated. They're variations on a theme and many, many cases across the world. But the idea here is the government has to do one of three things really. And to oversimplify, it's really two different theories. One is your country has done something to address climate change, but it hasn't been enough. And the Urgenda case is a good example of that. And remember, the Urgenda case was not just youth plaintiffs. It was a mix of plaintiffs, youth and adult. So the Colombia case was a youth plaintiff case, and in US, the Juliana case, exclusively a youth plaintiff case. So what we're seeing in Netherlands was an example of something had been done to address climate change, but it wasn't nearly enough. And the lawsuit is premised on this notion that on many different legal theories, the government has a duty to do more based on what we know about climate science and about duties under climate change legal commitments. In the Colombia scenario and the US scenario, it's a little bit different. And the scenario in Colombia was really ambitious and quite remarkable, that also remarkable that the Urgenda case ultimately succeeded at the highest court in the Netherlands, but perhaps more remarkable in Colombia that here we had, prior to the year that the lawsuit was filed, a 40% increase in deforestation in the Colombian Amazon. And of course, this is catastrophic for climate change, not just in the Amazon region, but for the world. These are the lungs of the planet, and we have governmental authority that is absolutely disregarding the stewardship that needs to occur, both domestically and internationally when it comes to managing the Amazon. And so this lawsuit was brought by youth that essentially their future is being stolen because of the absolute abject disregard of stewardship when it comes to managing the Colombian Amazon. And the complaint sought to have deforestation rates brought to zero. And ultimately, that's really what is necessary. That wasn't just a pie in the sky dream that was irrational. That's really where things need to be. And ultimately, the case prevailed on many different legal theories, which was quite remarkable. The decision reads like a poem. It's just incredibly philosophical and just brilliantly written about the need to be better environmental stewards and the urgency that we're currently facing. And so that case is similar to the US case in the sense that it is using the courts to essentially command a government to do something that is fundamentally discretionary. And this is really what's so earth-shattering about these youth climate cases. In law school, in the US anyway, you learn pretty early on that lawsuits against the government typically are filed on the basis of compelling governments to comply with non-discretionary duties. Essentially, a law says, government, you've got to do this. And if they fail to do that, a lawsuit can be filed to say, you didn't do what you were supposed to do. When we look at these youth climate cases, this is about a discretionary context where governments chose not to regulate climate change very well or at all. And the courts are being used as a lever to say, you need to make a different decision, even though you had the discretion to do otherwise. And that's really a watershed moment in environmental and climate change litigation. To the extent that theory prevailed in Colombia is quite compelling. To the extent that it's still a work in progress in the US is encouraging. The Juliana case was delayed for 3 years, the federal government using every trick in the book to try to keep this from going to trial. And in January, the latest iteration in that long saga is that the case was not allowed to proceed to trial. And an appeal on that is pending, an en banc appeal before the Ninth Circuit. And there are spin-off cases that are coming out of that as well. There are many cases that are happening at state level in the US and throughout the world, really, that are being inspired by the Juliana, the Urgenda, the Colombia litigation. Recent cases have been filed in South Korea, New Zealand on variations on these theories. And there's one in Canada that was filed in 2018, I believe. That's pending as well. So these cases are really inspiring. When I think about how much there is to be depressed about in devoting much of my career to climate change and what's happening or not happening in regulating climate change effectively, this is what keeps me going. These cases, even though they don't always win. It reminds me, in a 30+ year career in environmental law, if you take the long view, the right things have been happening. If you look at how the courts have been used to address results against non-compliant actors that thought they were untouchable, whether they be government or non-governmental, private sector actors, environmental litigation has ultimately achieved remarkable things. The only problem now is we don't have that much time. So when you look at how environmental litigation ultimately brought the lead paint industry, the asbestos industry, the tobacco industry, currently the opioid industry, and also currently a work in progress, the fossil fuel industry, to a point where they are either crippled or about to be crippled. It's really quite inspiring that the law can do this and the courts can do this. Ultimately should happen through the legislature, the legislative process, but that's not always how it happens if we've got legislative bodies that are not as responsive as they should be. So a seemingly unrelated piece of the Voiceless litigation is what's going on with wildlife. Now, this is really more about representation of voiceless entities that are vulnerable, have been harmed by certain climate change impacts. So these cases did not involve climate change impacts. These cases are about the notion of legal personhood for wildlife. So in the US, there have been cases that involved this famous picture here, the monkey selfie litigation of a macaque monkey that was taking photos of itself. And ultimately those photos were, his name is Naruto, and those photos were essentially going to be used for profit by the photographer. The photographer was aware that these monkeys like to take selfies and basically set up a tripod with a camera in the Indonesian rainforest, and the monkeys started taking great selfies. And this lawsuit was brought by PETA, an very well-known animal rights group, under the theory that these selfies should be the intellectual property of the monkey. And it wasn't so much about, the world's going to be a better place if the monkey ultimately has the intellectual property rights to the photos. It was really driven by this notion of recognition of legal personhood for wildlife, for non-humans. And the court ultimately rejected that in this case. It did not recognize that the Copyright Act's reference to person should include non-humans. That's just one case, but it's one of many so far where efforts have been made to seek to recognize animals as persons when a statute refers to, or a doctrine refers to person. And ultimately, courts have been reluctant to extend the notion of person beyond the human domain. But these cases have been quite persistent. Another line of cases is the Non-Human Rights Project, and these are habeas corpus petitions brought on behalf of chimpanzees and most recently elephants. And those petitions have not been successful to date, but they're getting closer and closer each time. There was a successful petition in Colombia, but that was ultimately reversed on appeal. That involved Chucho the bear. So what I want to take from this that's relevant for our discussion is the idea of personhood, legal personhood for non-human entities, and how the law can recognize that they have a right to vindicate rights, even though they're non-human, even though they can't speak for themselves in a court of law. And that parallels the notion of rights of nature. So we're seeing, unlike in the wildlife context, we're seeing remarkable developments in recognizing legal personhood for nature. For examples here, rivers. So in New Zealand, this was legislatively established in the context of the Wanganui River. There are guardians, government representatives, and indigenous representatives to speak for the river now. And it's a work in progress as to what that really entails. Does that mean now that the river has legal personhood, it is a zero pollution standard? That's going to be left for courts to determine. But what's different now is that the river has a legal voice, like a human. And that was also determined through courts stepping in. Even though cases in India and Colombia did not seek this status of legal personhood for the rivers, in both instances, we had rivers that were so flagrantly polluted that sua sponte, the courts in those cases said, this has to be the remedy if we're serious about protecting further degradation of these rivers. It's also been attempted in the US, not nearly as successful, not surprisingly. And one note there is particularly cogent in how far away we seem to be in some respects in the US for getting legal personhood for the voiceless. In a case that was brought on behalf of the Colorado River, the lawyer who brought that case seeking legal personhood for the Colorado River was threatened with sanctions if he didn't voluntarily dismiss that case. He was essentially perceived to be making a mockery of the legal system by trying to represent a river that ought to have legal personhood. And so that's quite a stark contrast to what we have seen in New Zealand and India, Colombia, really promising developments. So as far as the proposal is concerned, and very much consistent with the theme of the Journal of Sustainable Development Law, we have a principle, sustainable development, that has been in the works now for three decades, more or less. And this slide kind of tracks where we've been with our relationship to natural resources, to the voiceless. That initial era was essentially build, 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 drill, drill, drill. The planet is ours to use so we can advance economically. That finally came to a period of more sober reflection in the 1990s to the present, in that the notion of sustainability came to the scene, reminded us that this is not an inexhaustible bounty that we're working with, and ultimately we had to consider whether projects were sustainable in some way, depending on what the statutory scheme required. And yet, during this era, most projects proceeded anyway, that economics were still driving the game in most instances. We were talking a good game about the importance of sustainability, but ultimately it was very much like the first era. It's just that we were a little more environmentally conscious in this second era. So we are now entering a third era where we need to put our money where our mouth is when it comes to sustainability. And in this, moving from the second to the third era, sustainable development really has gained some traction. And jurists and scholars alike have made reference to the notion of sustainable development rising to the level of customary international law. It is becoming so widely adopted as if it were required by law to do so, and how we engage with the environment, how we develop, and how our development is relevant to environmental protection. So the proposal, the essence of the proposal that I'm making here is that sustainable development really needs to be a mandate if we are serious about protecting the voiceless communities. I'm going to give you some examples of that, how we're already seeing it, which is quite encouraging, but again, the clock is ticking in our ears, that it took 30 years just to get a little bit of teeth into this concept of sustainability. And we just don't have the luxury of another 30 years to grow a few more teeth. It has to be a transformation that's quite rapid. And we're seeing kind of flip of the switch transitions happening just in the past year or so, which are quite encouraging. So just a reminder of that working definition of sustainable development, it's important to be reminded that it does in fact include the reference to future generations, that future generations are supposed to be part of that process of determining what is sustainable. Current youth, the unborn, should be actively considered, their needs, when we're making development decisions today. So applied to the book proposal, the climate change crisis is really what could enable us to help turn that switch, to make sustainable development more of a mandate that we live by in all of our decisions, and not just some kind of lip service to proceed with business as usual. So there are different ways to achieve that. Certainly there are regulatory bodies that could be very protective of the voiceless. And I certainly want to focus on the second and third points here, that raising the government's mandate to be better stewards and ultimately enabling action on a rights-based approach to have voiceless communities vindicate when their rights have been violated. That's really what is the essence of the proposal. It's important to understand that we already have future generations commissions in many countries, and that's something that should continue, should really take off. That's one way of making sure that the voiceless have a voice in legislative processes. We also have some bodies that are meant to represent voiceless entities in the court system. Rights of nature tribunals are one example of that. And we have a long way to go with that. Rights of nature tribunals right now are not traditional courts that are able to make binding resolutions the way traditional courts do, but at least it's getting out there into the public's eye and into the dialogue. One example I want to share, and there are examples from Canada that have been promising in this regard, kind of integrating climate change and the urgency of climate change as a way of halting a project from going forward as planned initially or at all. But the best example I have to share with you is from a year ago in Australia, and it's known as the Gloucester Limited case, and it's just brilliantly written by a famous jurist in Australia. And ultimately, I'm oversimplifying, but a big premise of that case, something that should be widely adopted as possible, was this notion of a carbon budget. And the reasoning of a carbon budget ultimately led the court to conclude that this particular proposed coal mine was going to create such a significant increase in greenhouse gas emissions that it was ultimately unsustainable, that it would put the country outside of its carbon budget allowance. And when you think about how simple, how elegant that is in its simplicity, and we've done this in all other contexts, many other contexts outside of environmental law. The idea is you identify a standard, and that's going to take some time. Quantifying what we mean by sustainable development could mean a lot of different things. But in the climate change context, I think it's quite easy to quantify that ultimately science is telling us we can emit so much. And if we go beyond that, we are catapulting ourselves toward catastrophe at a planetary level. So it seems quite readily attainable to develop a carbon budget kind of standard on a sustainable development sort of premise that this sort of massive coal mine does not meet that standard, whereas a green energy proposal certainly likely would. And right now, politics drive those outcomes really more than anything else, that we've got lots of major fundamentally unsustainable projects still going forward in countries like US, Canada, and Australia, the three musketeers in terms of coal-fired based exploitation when they ought to be doing a better job. And that is starting to change when you've got cases like this that are asking us to rethink how we go about addressing these concerns. And there's just a recent law in New York that kind of builds in this notion that there's a law that's called Restore Mother Nature Act that's being proposed in New York, and it's a massive investment of funds to support environmental agencies in that state so that they can support nature-based restoration projects that will address climate change adaptation concerns, flood mitigation, restoration of ecosystems, and so forth, to build climate change resilience. It's very much an ecocentric idea. And likewise, this case is also very much of an ecocentric thinking, this Gloucester Limited case, which ultimately did not allow something that used to be just a rubber stamp. Next major coal project, come right up, we're going to approve you. Now, perhaps not so much as readily anyway. So an example of how these stewardship models might take hold. Ultimately, someone has to be the steward. So that's going to vary depending on the context. You're going to have different regulatory bodies that might be playing stewardship roles. You might have appointed guardians, legal guardians who serve those roles. In the US, we have precedent for the government being a trustee for natural resource damage recovery. So there are ways of first identifying a particular stewardship responsibility. There are a lot of different ways to do that. And in the climate change context, much of that is driven by the science, that the science establishes for us we have to be more protective of how much we are emitting. That is ultimately accelerating this problem we're facing. So in terms of implementing those protections to ensure that the government is held to those stewardship obligations, I use this undue burden standard from constitutional law in the US, and I don't mean to connect this to future generations in any way. I'm not talking about abortion in a substantive way. I'm talking about it in the way that it has become our constitutional standards. 2 words, undue burden. And undue burden in this context means a woman has a right to choose, constitutionally protected right to choose, under certain circumstances, whether to proceed with an abortion. And the way the law evaluates that is if you've got a certain state restriction on a woman's right to choose, that is going to be evaluated under this 2-word standard. Does that state restriction that limits her right to choose amount to an undue burden on her right to choose? And I use that reference point because that's an incredibly imprecise standard. we don't have an inherent sense of what undue burden means. We've got to sort through that. We've got to have multiple cases give some kind of parameters. And likewise, sustainable development has a similar ring. It's a very imprecise, aspirational sort of standard, but over time, it can be quantified to mean certain things in different contexts. And ultimately, in the climate change context, again, that can be something that is driven by the science and that is somehow framed in a carbon budget sort of way that will limit how much can be emitted. That is essentially the government's responsibility to ensure, and we need a broader opportunity across the voiceless communities to have an opportunity to say that standard has not been met, and therefore we're going to sue to make sure it is. So the whole line of cases we're seeing across the 3 voiceless communities right now are getting us there, but the right way to do this is legislatively, and it's ultimately starting to happen very incrementally. But how to enforce this, there are certain opportunities. One example is in the US, we have what's called a next friend mechanism in our federal rules of civil procedure. And that's essentially the opportunity to represent another person who is not able to represent him or herself due to incapacity. So this might enable someone to represent someone who is in a coma or mentally disabled. But that notion of person is open to interpretation, and that could be extended to the non-human domain, to the voiceless communities, whether it be wildlife, resources, or unborn humans. Ultimately, this is a way that the law could recognize that those vulnerable communities, the ones that are poised to experience these challenges first and worst, do have a voice in the legal system to push back against policies that are not adequately protecting them. And ultimately, I'll return back to that theme that I started with. A lot of times I'll hear that, well, how can we afford to care about the voiceless when we're not even doing an adequate job of protecting adult humans? And the idea is, once again, that doing a better job of protecting the voiceless is helping adult humans, in addition to fulfilling our stewardship, our moral and legal stewardship obligations to protect the voiceless. And again, the ecocentric model does not look at that divide between human and non-human. We are in this together, and working together in more effective ways, in more ecocentric driven ways, will be in the interest of all of us to continue to share the planet in a way that is sustainable moving forward. So I look forward to hearing your questions and having a dialogue. Thank you very much for your attention.
Thank you so much for your presentation, Professor Abate. Just to remind everybody, and for those who may have entered after our brief introduction, you can feel free to either unmute your microphone and ask questions directly, or you can include your questions in the chat and we will read them out loud and address them.
I'm just seeing one comment so far regarding the Atrato River case in New Zealand. I'm sorry, in Colombia. It says there's now a collaboration between government entities outside of the court, including the Attorney General of the nation, and I believe the River Guardians are working on a legal framework for how to understand the river, but it looks like they're not categorizing it as a form of personhood, but shaping it as a new legal framework that requires that the Atrato's voice is represented in all decision-making processes, as well as represented in court. The new framework for the Atrato is expected to be transversal. the definition will be confirmed and issued by government authorities, and the court no longer has a direct role in shaping the definition. So I would comment on this as something that's quite positive, and also mention that rights of nature protections can take a variety of forms, and one is this notion of legal personality, but there's another one that's even stronger. That's essentially this true rights of nature perspective, that that nature has intrinsic value and ultimately has a right to be able to flourish. And so those approaches are underway in the US, I know, in a lot of local communities. There are rights of nature ordinances that are seeking to protect certain aspects of communities from development. Fracking has been a common focus. So if a rights of nature ordinance is in place in a particular community, it has been used as a shield against potential fracking operations that would ultimately disrupt the environmental integrity of that community through a rights of nature lens. I don't see anything else on the chat if I'm reading it properly.
Hello, Professor Abate. Thank you very much for your talk. I just wanted to reach out and talk about maybe more ways in which people can bring up the discussion of climate change and all like the sort of issues that feed and don't help the process. I'm currently completing a Master's of Environmental Sustainability at Ottawa, which is in Canada. I'm always trying to think about all the ways that we can be more effective at what we're doing, because we are kind of training for this skill, and just trying to get your opinion as to how else we can kind of cultivate the movement and make it more popular, if you will.
Yeah, it's a very big question, and so this is just a small slice of it. What you've heard today, that climate justice litigation is one way of getting governments to do a better job in regulating climate change, but it is so intersectional with so many other areas. So addressing climate change effectively intersects with energy policy. So we can do a better job at the front end if we are using both legislative processes and judicial processes to promote a transition to cleaner energy. So on the front end, we're going to have less of a mess to clean up on the back end through the courts if we're able to get to a clean energy transition. And I've seen a lot of encouraging developments there that have been quite ambitious of late. So this has been true in more of the green-minded countries, as well as some that aren't as well known to be green-minded. And so one example is in Germany, a green-minded example that they've pledged to go to decommission all coal-fired power plants by 2030. Mm-hmm. And that's quite ambitious, and a country like Germany could very well be able to do that because they're well along the road in transitioning to clean energy. Other places that are quite well known for coal exploitation as their primary means of energy. Poland is an example, and there was just a lawsuit filed in Poland where there's an effort to get zero net emissions from coal-fired power plants in a particular region of Poland by 2030. So the thinking is quite powerful. The thinking rubs off in many ways in other places and other contexts, that if you have to dream it first, and that's something that in the U.S. was so powerful about the Green New Deal. I mean, even liberal environmentalists laughed at it at first. I mean, it's seeking for the U.S. to go, carbon zero net carbon emissions in 20 years. I mean, it's just never going to happen. But you have to at least try to get there first. And ultimately, the value of that is that it's created dialogue that we weren't having. So now that the Green New Deal is something that is being supported by more than 100 members of Congress, that's a huge development. Whereas just a year ago, we didn't even have 100 members of Congress supporting a carbon tax. So the fact that it's just being presented into the dialogue is really powerful. And that's true at a political level, that's also true at a social level. So certainly at all levels of governance, whether we're talking federal, state, local, any kind of way of changing some of the primary drivers of what's causing the climate change problem is quite powerful. And I think the best example that I'm seeing in the US in terms of a revolution that I think could make a massive impact is food choices. And this doesn't come on the top of everyone's list when it comes to combating climate change, but to me, factory farms are every bit as destructive as coal-fired power plants when we're talking about the future of our planet. And if we drive down the demand for what factory farms produce and how they produce it, that's a massive win for on so many levels in terms of destruction of the environment, animal welfare issues, public health issues, and the healthcare costs associated with a meat-based diet. So you have to look at the issue of climate change for what it is, how many contributors there are to the issue, and then selectively focus on a few that are attainable at a more local level, at an advocacy level.
Yeah, thank you.
Sure.
So we have a question in the chat.
Can I make a question?
Yes, sure.
Yes. In Italy, the legitimation to file a lawsuit to seek damages for environmental pollution is for the state. So the state is the only subject entitled to file a lawsuit to seek damages. But when speaking about environmental law and when speaking about environment, generally people say that environment, broadly speaking, is public. But don't you think that public, the meaning of public should be transformed in order to allow more participative, in order to allow a more direct participation of people into the public management of the environment, and also in order to broaden the possibilities of people to file a lawsuit to safeguard the environment. Because, for example, according to our civil procedure code, you can file a lawsuit only if your interest is current and concrete. And I don't think that in our system currently the protection of future generations could be allowed. Also because the interest of a citizen is not deemed as sufficiently direct in relation to the environment. So don't you think that what we call public should be more public?
Yes, I think that's a great question and observation. So I want to take that point that you raised toward the end regarding this, really what's related to the concept of standing in U.S. law, the idea of what enables you to go to court, to be considered a proper party. You have to have a concrete, a particularized injury. And you raise a very good point that ultimately the protection of future generations is a challenge from a standing perspective. And that's why these particular governmental bodies are best suited to ultimately be the voice of these future generations in court. And they are in a stewardship role, and to the extent that they have been legislatively established to do that, that is the best way to do it. In the US, it's very difficult to do that, if not impossible, when you are a party trying to represent the interests of another party. That's known as third party standing, and that's not permitted. there is an exception to that, though, and that is if you are the legal guardian to represent the view of that particular other party, then it's okay. So, for instance, we have laws in family law that permit the appointment of a guardian to represent the interests of a child in a custody dispute. Someone who is of minority age and is ultimately that child's interest is going to be represented by an adult guardian. So you are correct that this notion of public should be more inclusive, and that's really what these youth-based cases are all about. That these used to be exclusively in the domain of governmental actors to determine what's an appropriate level of regulation, and now essentially it's tantamount to a coup when you think about the effect of these cases, that what used to be exclusively within a government's discretion is now the public is seeking to take that away from the government and say, no, we're not going to stand for that decision, which used to be just unquestionable in terms of a government's discretion to act. Now it's on a rights-based theory, not going to be tolerated, and many of these cases are really undoing that long tradition of the government is the public, and that's the only way it's going to be managed. So we're seeing a transformation in progress.
Thank you very much.
Certainly. I see a question here regarding stewardship responsibilities that many indigenous peoples have assumed and still do assume with respect to nature. I'd like to know if you believe they should or could assume a special role in the Rights of Nature project in North America. Well, I think that's a very good point, and it's another way of perhaps limiting the effect of what we see with the Wanganui case context in New Zealand. The reason why the Wanganui River was granted legal personhood, by and large, was because of the Maoris' historical and deep cultural ties to the river. And it was also a settlement of a long-standing dispute between the government and the Maori in terms of the government not fulfilling some of its treaty obligations toward the Maori. So it isn't a typical case that way, that indigenous communities are a special class of entities when it comes to rights of nature. I think the law reflects this, and I think that's really where I come down as someone who's written about climate change and indigenous peoples. When you have an indigenous community that is legally protected as having a relationship to nature that is somewhat more special and more established than the rest of us, and that's been recognized in treaties, and that's been recognized through court decisions, whether it be hunting and fishing rights or spiritual connections to land, it really has been distinct, and that's quite powerful, to the extent that those legal protections for indigenous communities can be leveraged to do more for protection of nature. That's absolutely something that is happening and should be happening. And so one of the spin-off cases that I mentioned and didn't get to explain did happen in New Zealand. That's currently happening. It is involving an indigenous community's claim regarding climate change, and that is kind of a reflection, I think, of one of the points that you're getting at here, that relying on indigenous communities to spearhead some of these protections for rights of nature is a very good path. And it's not so much us versus them. I just think that the general public and indigenous communities ought to be protected more effectively. It's just that the indigenous peoples are always going to have a little bit more, and rightfully so, for a variety of reasons, colonialization history and relationship to the lands that they've historically occupied. So I see some other questions coming up here. I see public trust. That's something that's one of my favorites, so I'll jump to that. What is the extent of the public trust doctrine when it comes to environmental laws in the US? Are there any instances when the general public can defend nature based on the public trust doctrine? Couple of different ways to address this. First thing to understand is that the public trust doctrine is narrow in its foundation. And this is yet another example of how inspiring it is to see creative environmental lawyering in action. So the public trust doctrine was a doctrine that the US inherited from England and ultimately applied to the states. It's a state law doctrine in the US, although there's some dispute about that. And basically, it is about the state acting as a steward on behalf of the citizens of the state to protect the wet sands near the oceans that are held in trust by the state to protect, to hold in trust on behalf of the people, and the riverbeds for freshwater and lakes on behalf of the people. So an example would be that the government would not be able to allow someone to build a resort in the wet sands. Those are public lands that cannot be alienated. And so the question here, as far as what the public trust allows in terms of protecting the public, has been expanded over time. So initially, the uses, the interests that were protected by the public trust doctrine were just fishing, navigation, and commerce. And that has evolved over time to also now protect wildlife, wetlands, and even beach access on the dry sand level to get to the wet sands. And most recently, the really profound shift that is a work in progress is this idea of atmospheric trust litigation. So that's what the Juliana case is premised on. And here the notion is that since we've seen this incremental expansion of the government as a steward of resources on behalf of the public, why can't we also say that the government is the steward of the atmosphere on behalf of the public, and therefore a failure to regulate climate change is an abrogation of that government's trustee role of protecting the atmosphere and its integrity for the benefit of the citizens. So that's what's going on, one aspect of what's going on in the Juliana case. That's the government stewardship piece. The other piece, the rights-based piece, I think is even more interesting, and that's unrelated to the public trust, but that is based on our due process clause of the Constitution. And ultimately, the argument is that there should be a right to a stable climate, because we've seen a broad interpretation of what it means for the due process clause to protect life and liberty. And essentially, the argument would go that the right to a stable climate is so fundamental that it's the foundation for enjoyment of any other right that's protected by the Constitution. So how can we say that the due process clause wouldn't protect a right to a stable climate? And this very argument was used in the recent same-sex marriage case before the US Supreme Court, that the idea of the right to marry as being so fundamental as a platform for the enjoyment of other rights was what led the court to ultimately conclude that same-sex marriage should be protected as a fundamental right under the due process clause. So that's the argument on the rights-based side for Juliana. But this question was focusing on public trust. And so another dimension of how public trust is starting to be used is there's an effort to use it to protect wildlife. And ultimately that's also a work in progress, because that is an extension from its foundations in wet sands and river and lake beds. So it's really a creative work in progress, and I'm very encouraged by what's been happening. So that's how I would respond to that one. I see a question here about environmental personhood for protecting international wildlife. There's a crossover between endangered species policy and preventing the rise of novel viruses. In 2016, the Convention on International Trade in Endangered Species, CITES, added all 8 species of pangolin to Appendix 1 reserved for the strictest prohibitions on animals threatened with extinction. And despite this listing in CITES and some recent efforts from China, the illegal wildlife trade has reached its greatest heights in the last few years because of the immense wealth associated with wildlife trafficking. How would you suggest to better strengthen international wildlife laws and help prevent the next COVID-19? Yeah, that's a big question, but a certainly timely one. So one thing, again, looking at it from the way I look at climate change, the COVID crisis is an absolute tragedy. And at the same time, it's a tremendous opportunity. So I think more so than ever before, this crisis is drawing attention to the fact that trade and consumption of wildlife is very, very dangerous for sustainable life on the planet. So and this has happened in the past. So China has responded in previous wildlife-related outbreaks to then say we're prohibiting it initially in response, and then the restrictions are backed off from when the crisis subsides. So China has again prohibited what has been perceived to be the cause of this global pandemic, and that's to be expected, both at a domestic and an international level. But again, it's about driving down the demand for these harmful practices, and again, from that perspective of our food choices, it is about advocacy at a grassroots level. So shark finning is another example, just an incredibly destructive, abusive practice of a species of wildlife that's already imperiled. And ultimately, there's been so much more discussion of this practice. I wasn't even aware of shark finning, and I'm an environmental law professor until like 5 years ago. It's been going on for decades. And so just the raising of awareness that comes with a particular crisis and using that for leverage for advocacy is very powerful. So I think that CITES has been a very effective law in the grand scheme of things, but CITES is not the answer for stopping these harmful drivers of international trade in wildlife. It has to be taken from a perspective of driving down demand. That's ultimately what's going to shut down everything. Driving down demand for coal-fired power plants, driving down demand for factory farms, driving down demand for other abusive practices that have caused this prolific wildlife trade. It's a very slow process, but I think ultimately the COVID-19 crisis was such a wake-up call and such a scare for humanity that this is an incredibly opportunistic moment in history to do the right thing and not feel like we're giving up much to do the right thing. And I think that was true of climate change, as far as I'm concerned. We're getting that message from the Intergovernmental Panel on Climate Change almost every day. The clock is ticking. We have to act aggressively and ambitiously, or incremental steps are for last. Yesterday, so to speak. There's a comment, a shark finning video was one of the reasons I began an environmental career. I'm glad to hear that. Trying to see if I missed. I don't think I missed any questions. Are there any other questions?
Hello, my name is Jimena.
Hello.
Thank you, Professor, for your talk. I have a question, and I see the message that you give us that there have been progresses if you see the overall picture, although the progresses are not fast enough. And I want to know, from your point of view, what will be, in the shortest term, the most immediate challenges that we would face for a more successful litigation, and what advice you could give us for ways to identify these main challenges and think about them, not only within the failures that we've had, but what you envision that will happen in the current political climate.
Yeah, there's a lot to that question. I can certainly address it from a U.S. perspective. One thing that I'm encouraged by in what science is telling us is, in the past year alone, the U.S. has witnessed, for the first time, all of the Democratic candidates for the presidential nomination in November using climate change as one of their 3 principal issues for why they're going to get elected. And that was always lip service at best in the past. Even 4 years ago, there was significantly less discussion of climate change as why, my climate change policy as a fundamental piece of why you should elect me. So I think that is very encouraging. And again, there are so many levels at which politics are involved here. So it is about presidential elections, but perhaps more importantly, it's about congressional elections in the US. We can have the most fantastic president on climate change, and if we continue to have a dysfunctional Congress, it really won't matter. We'll talk a good game as a country, but genuine action won't occur. So I can't stress enough how elections are so critical now when it comes to where we're moving in terms of climate action in the US and elsewhere. And I'm seeing some glimmers of hope there. I think that there has been a progression of just the past year of an awareness that it's not about one or the other, economic progress or climate regulation. They are similar to the 1970s. They are being perceived as interconnected. That climate change is something that has to be regulated regardless of what our economic objectives are. If we're serious about achieving economic progress, we have to do so in a way that effectively addresses climate change, because the dollar figures are staggering. So one of the narratives that I find very encouraging is that it's more expensive to wait for disasters to happen and try to remedy them, climate change impacts, than it is to upfront do effective mitigation efforts and planning, and pay a little bit on the front end instead of much more on the back end. So that's becoming more common in the dialogue. And then the other piece is that the litigation effort is really just a public advocacy campaign that's very effective. It really doesn't matter whether these cases ultimately win. It's wonderful if they do. But for me, what's been most powerful about climate justice litigation is the fact that it's created the climate justice movement, that this is being discussed every day in every coffee shop throughout the country, to varying degrees, that this is really the issue of our generation, that climate change cannot be ignored anymore. And so I'm encouraged by the information campaign, the science behind the information campaign, and we're never going to be at a place as bad as we've been in the US anyway in the past 4 years. It's just impossible. And again, that's because of the advocacy. That we may not get to a much better place, but I think we've hit rock bottom, and that's encouraging. That it just can't get any worse as far as climate regulation. And elsewhere around the world, there are very, very different contexts. I'm seeing a lot of rapid progress in places I didn't expect on addressing climate protection. The US has the advantage of being very effective at enforcing things that are in place, but we're not very good about putting the things in place in the first instance to protect the environment. And the developing world has the opposite problem. There are many very ambitious laws that have not been adequately enforced. So again, climate change is a global issue, and our global cooperation has to improve, and that's been a real challenge too at the UN COP level. Got to do better there, and I'm not sure that we will. I think the answers are more at the regional and national levels to make effective gains on climate regulation. See another question here about, have you come across the discussions of cradle to cradle and the upcycle from Michael Rongard and William McDonough? They have been writing about sustainable development and the possibility of economy and environment to merge effectively. I'm familiar with that general concept, that ultimately, I think economy and environment are much closer today as having this kind of symbiotic relationship than they were 10, 20, 30 years ago, for sure. I think that we're getting there more readily outside of the governmental domain. And that's part of where my book proposal was, that the governmental domain has to embrace that interconnectedness of economy and environment, the way we're seeing much more commonly in the private sector. And the private sector needs to be a leader. Ultimately, the public drives what the private sector peddles. And the private sector, in turn, is a very effective influence on government policy. So if you take an example of industry that back in the 1970s literally lobbied Congress to regulate air pollution because industry was concerned about having different state standards with its operations in different places. That's ultimately the way you get effective governmental regulation, is consumer demand informs the practices of private sector entities, and then the private sector entities say, this is what we need. And I think we're making progress on those fronts. I think ultimately we've come a long way in consumer interests influencing the private sector, and now we just have to make that a little stronger from the private sector's perspective to get the regulation to make their practices more predictable so that they can ensure their profits, and ultimately to be responsive to the public's expectations. The U.S. District Court judge recently overturned the Toledo, Ohio citizens' attempts to recognize Lake Erie as a rights holder on account of vagueness. Can you discuss the issue of vagueness in the context of these issues? What are lawyering techniques to prevent these proposals from being dismissed as vague? That's a good question. I haven't encountered that particular argument, but I suspect where it's coming from is something that's been a challenge for state constitutional provisions as well, that have a right to a clean environment, for instance, language in it. When you have very broad-based aspirational language like rights of nature or a right to a healthy environment, we all have a sense of what that means, but when it comes to translating that into a legal commitment on behalf of regulators, it's very commonly determined to be insufficiently precise, legally vague. And so that's what I'm suspecting is happening with this, this rights of nature protection for Lake Erie, that ultimately it was something that was certainly well-intentioned and appropriate, but when it comes to translating what that really means in the concrete legal obligations, we're still not quite there. And that was related to the point I said about sustainable development, that it's going to be a progression about what it means to translate something as broad-based as a right of nature, or what it means to be sustainable in terms of an operative definition that is embraced by regulators and regulated communities. So that's really where I see that is where that's coming from. I came from an area heavily dependent on oil and gas. What advice might you have for cities' populations faced with the question of transitioning away from fossil fuels? This is very difficult. And when we talk about a transition away from oil and gas, my perspective on this is not an instantaneous global transition at all, nor should it be. I mean, this is why we're having dialogues at the International Climate talks regarding common but differentiated responsibility. And by that, I mean the developed world has the primary obligation to lead that transition. We have reached a point of economic progress and stability that our economies can endure that initial hit economically as the transition occurs. And many say it's not even going to be much of a hit. But when we're talking about developing countries that have a heavy reliance on oil and gas, they should not be held to that same standard of transitioning away 10 years from now, the way we should in the developed world. So I think that the way that can occur is based on the principle of common but differentiated responsibility, in that the developed world leads that parade and ultimately assists the developing world in facilitating their transition that comes a bit later. So there would be a lot of flow of money and technology from the developed world to the developing worlds to assist in that transition away from oil and gas. It's not going to happen overnight, and it's not going to happen without the developed world's assistance. It just wouldn't be fair, and it wouldn't be possible. If I am remembering correctly, there has been some movement discussion about classifying carbon dioxide as a pollutant under the Clean Air Act. Theoretically, it might be possible to classify carbon dioxide under CERCLA as well, and consequently put the responsibility on the fossil fuel industry to essentially clean up the mess they created. What are your thoughts on the possible effectiveness of incorporating existing laws and statutes to fight climate? I'm all in favor of it. So you are correct that the first step in that process was the Massachusetts versus EPA case, and that was in 2007 in the US, where the court ultimately concluded that carbon dioxide should be considered a regulated pollutant when it comes to emissions from motor vehicles. And that was a long court battle in implementing that decision over a decade, and then we finally got something out of it at the tail end of the Obama era, and then it was undone in the Trump administration. So that was a very hot political battle. But in the meantime, many other statutes, I haven't heard the argument about CERCLA, that's quite creative. Many other statutes have been used as a leverage point for climate change regulation. So the Endangered Species is a prominent example. Endangered Species Act is a prominent example. The polar bear was listed as a threatened species about 15 years ago now, solely because of the climate change impacts of a melting Arctic. And also there has been very effective use of NEPA, National Environmental Policy Act, our environmental assessment law, to require considerations of climate change impacts as part of what is considered environmental impacts of a proposed federal agency project, and some of those decisions have been delayed or ultimately not pursued because of those impacts on climate change. So there's a lot out there, both at the federal and state level, to creatively retool existing laws, because we don't have a climate change law yet, which is just shocking in 2020. We don't have a federal climate change law, so that's what environmental lawyers have been up to, very creative ways of engaging existing laws and largely engaging the courts through common law theories as well, public trust, public nuisance, even securities litigation to try to hold companies like Exxon accountable for how they're managing disclosures about climate change risk. So it's an all hands on deck proposition, and it's important to consider things very creatively in a broad-based way. In the transition from NAFTA to USMCA, do you see the potential progression, regression on environmental policies for the three countries? And given this agreement, do you see it as a positive way to continue moving forward? As an American studying here in Canada, I'm particularly interested in ways that I can help our countries work together, since they have so much power and influence on each other and the rest of the world. I have to be honest and say I don't know as much about that. And I can certainly say that there's a lot of connection between international trade regulation and climate change. And I think it's certainly a very effective component of making progress on climate change regulation, and certainly the intersection of trade and environment more broadly is very, very important. And this is one of many tools in that toolbox to make steps forward. Beyond that, I don't have specific comments on this particular transition. It just is not an issue I've worked on lately, but it's a very important one to consider. And I agree with you that continental initiatives are ultimately going to be very, very important in making climate change and environmental progress moving forward, because we are just not getting it done at the global level for a variety of reasons. So I think that's very important to bear in mind. I was on a call yesterday which referenced efforts to use intellectual property laws to patent nature's creative processes and create a trusteeship to contribute to that natural entity. I'm not clear on some of the legal terminology with this kind of idea, but I'm interested in knowing if you've heard about any of these initiatives. That's certainly, in a general way, things that I've heard about, but not this particular point. The idea is ultimately based on a rights of nature concept that in many ways some companies have used the leverage of intellectual property to facilitate their exploitation of nature by patenting different processes in their production. And this is really a way of pushing back from an ecocentric perspective to ultimately protect nature as having some kind of intrinsic value and protection under a very creative, through a creative process with intellectual property laws, which is unusual as a tool for environmental protection. But I'm all for it, and it's something that I would be interesting to see where it goes. But I certainly haven't been exposed to it in any detail. Don't see any new questions.
All right, so unless there are any further questions, maybe we'll just begin to wrap things up. Professor Abate, thank you so much for your enlightening presentation and for informing us about your compelling and important research. These topics are incredibly pertinent and thought-provoking, especially during these times. And this has certainly been an opportunity to encourage us to consider legal stewardship, obligations to protect the voiceless in the interests of us all and as well as for future generations. So I'd also like to thank our diverse audience for being here with us and for allowing us to have an insightful and interactive session. Stay tuned for more of our events and check out our website for forthcoming articles, blogs, and podcasts relating to more pertinent topics on sustainable development law. So on behalf of the MJSDL, I'd like to wish everybody a wonderful afternoon. Stay well and stay safe. Thank you so much.
Thank you.
Thank you.
Thank you.
Thank you so much.
Bye.
Hi, thank you.